Want to look at the judicial branch a little bit here today. Um, as we lead up to our first exam, uh, talking about judicial branch, first thing you need to know is there's two types of law: criminal and civil. Um, I think of it pretty simply that criminal law is when you break a law, and civil law is resolving it. It could be a divorce. It could be someone suing someone else. Again, most cases are resolved in state court, not federal courts, but we do have a pretty strong um, federal system. So, just a couple background things here: plaintiff, defendant, jury. Um, Probably stuff that you already know. I'm not gonna go into this a whole lot, but just some background information on the judicial system. A couple things you probably don't know. One of the biggest um, things I want to talk about here is amicus curiae briefs. We'll bring that up again when we talk about interest groups because they use this a lot. It's often called a friend of the court briefs, and what it does is, say you have a case where the question is abortion, you're probably going to get a friend of the court brief from anti-abortion groups and groups like Planned Parenthood. It's kind of like a third party weighing in on the case. A couple things with attorneys here. Just a couple important statistics. Um, this is a look at the federal judicial system, which could be important to you. Um, if you want to focus, the most important place to focus is on the two categories in the middle: the courts of appeals and the district courts. 91 district courts and 12 courts of appeals in the country, leading up to the Supreme Court. These district courts are what we would say have original jurisdiction. They're the first court to hear a case, um, and they determine the facts. It's basically a trial court. There's one in Harrisburg. You can see what types of cases they deal with here. Quite a different, a broad spectrum, if you would, of different cases. We then move up to our appellate jurisdiction, where these are courts that are reviewing issues from other cases. So they're reviewing the decision of other courts. This is judicial review, which you would have learned about before break. Again, 12 of these courts of appeals, they hear very specialized cases. Um, we hear a lot about it with the travel ban. They're hearing it now on some amnesty issues brought by basically by the Trump administration. And again, you're talking about errors of procedure and law. So if a executive order were to be challenged, it would be challenged in these courts. Moving up to the Supreme Court's a little different because it can have original jurisdiction or appellate jurisdiction. You can see some of the numbers there: 9 justices, 8 associate, 1 chief justice, and pretty much what they do. Most of their cases come from federal courts and are federal cases. Most are civil, which a lot of people would probably say that surprises them. They would think they would be criminal. They're mostly civil. This is a good graphic of the Supreme Court. Gives you a good idea of how an original jurisdiction case could get to the Supreme Court. Here's where the cases come from. Again, an interesting graphic. You can look at 51, from the lower courts. This is from a while ago. It's from the 2005 term, but I bet you if you looked at the numbers from today, they'd be nearly the same. So moving into kind of a different area, judicial selection. Um, how do we pick Supreme Court justices. There's not a lot of constraints on the president. It's very important to screen the candidates. As we've seen, we can have a confirmation hearing that can be drawn out a lot, and that's even with the Kavanaugh situation is even with a Democratic Senate, or not a Democratic Senate, a Republican Senate. Just think if it was a Democratic Senate, how it probably wouldn't have happened. 1 out of 5 don't make it. So again, what I just said, if you have minority party support, it's going to be much more difficult. Chief Justice can be chosen from a sitting justice, or it can be a new member. The last time when President Bush did this, he nominated Chief Justice Roberts. He came as a new member and became the Chief Justice. So historically, these have been white males. They're always lawyers with judicial and often some political experience. They're usually the same party and ideology as the president. But once they get on there, they may not rule the way the presidents had hoped they would have. Think about Marshall and Marbury versus Madison. This just gives you a little idea of the background of judges and who's appointed who and whatnot. Much more diversity today than there has been in the past. One of the big issues that we deal with is the court making policy. First of all, for a case to get to the Supreme Court, that we use the rule of 4. If 4 of the 9 justices want to hear it, then it goes to the court. They then issue what's called a writ of certiorari that call up the case. You can see here the role of the Solicitor General. Not a really highly publicized role, but it's still an important function nonetheless. So again, you can hear some of the other stuff, see some of the other stuff here. Justices hear oral arguments from lawyers. They discuss the case. They then write a majority opinion. They write dissenting opinions, and then somebody may write the concurring opinion. They don't always have to do that. What happens a lot of times is this idea of stare decisis, which means they're going to let the previous decision stand unchanged. If you look at a majority of their cases, stare decisis usually comes in. Once they do that, once they make a decision in the case, they set a precedent, and that sets an example for the other courts. Any decision can be overruled. One of the big things they talk about is an original intent, and how the Constitution should be viewed according to the intent of the framers. So what did the framers mean when they wrote the Constitution? Judicial implementation is an important idea. They're going to make this decision, but ultimately they're relying on other people to carry out the decisions. All right, you can see some of the stuff there. Courts aren't democratic. They're not elected. It's difficult to remove judges and justices. They sometimes reflect popular majorities. This is kind of one of the big ideas of pluralism here, is using the courts when other methods fail. There's often conflicting rulings, which cause some issues. More about judicial activism, but you can see the two different kinds. The first one is kind of the conservative model, where judges play a minimal policy-making role. Judicial activism is a more liberal stance where they can make policy decisions, basically. That's basically it. Please, if you have questions